one is appealing for the
Order one for imposition of the.
why, Mr. Rai, in all matters, reimposition?
Well, they refused. Opposite party.
He is appearing.
No. Well, item 11 block.
Item 11, its entry order is still October.
But it has been vacated by Lords. It is vacated, my lord.
When it has been vacated?
On 5th of August, my lord.
Why?
My lord, they filed a vacating application on that day. I missed the list, my lord.
Then it cannot be automatic extension. You have to file an application.
I have filed an application. That is before Lordship.
Have you served that application
Yes.
on the other side? Who is appealing for the other side?
Okay, Mr. Anonna Udhikari, I have served.
Where is the evidence service?
My lord.
Agatta di-
Simply sorry, my lord.
Where is she?
I have served, my lord.
Ask her to come. Please inform her. Ask her to come at 2 p.m.
2 p.m. Grateful to.
So, Dr. Please call the next matter.
Well,
Yes, Mr. Rai.
he refused, my lord. There is duration of service. It is refused.
This is an application for extension of interim order. Then how it can be reimposed, Mr. Rai?
It is Supreme Court. The matter is pending before your lordship. My lord can consider the merits and the basis of which my lord can pass an order.
You have to explain the reasons why you did not take steps for
It was
extension.
mentioned subsequent, but at that point, my lord is of the opinion the interim
And
order
I'm appealing for the
For the petition.
sir.
Sub ballot
Receive
10.
10.
10.
Why?
But my lord, it has not been my lord served in my lord, but track report is concerned. But my lord, last 2 occasions, my lord, they did not appear. First extension was made, my
No, this is can.
10.
Can.
For extension of interim order,
Can number?
can 3.
Can 3.
Yes. It was extended, my lord, up to 31st August. And my lord,
Up to 31st of August. Can 3 of can 3 can 3 of 2025. This is an application for extension of interim order. First of the learned advocate appealing for the petition.
I appear for the opposite party, madam.
I appear for the petition, whether the interim order will be subsisting millet is still expiring in the end of August.
After hearing the learned advocates for the respective parties, the interim order is
I'm appearing on behalf of the petitioner. Kindly, my lord, have a look at my lord's own order passed on 21st
Lord,
May.
I am there online.
My lord, everything is clearly spelled out there.
Lord, I am there
Yes.
online.
My lord, from a suit, valued at
What
1,65,000
that
and
matter. What happened? I think I directed this appeal to be disposed of.
no, my lord, the injunction order was stayed, and since we have challenged the maintainability of the appeal itself, because the appeal was preferred before the learned district judge from an order passed in a suit valued at 1,65,000.
Yes.
So, the appeal itself was not maintainable by reason of the Bengal Agra and Assam Civil Courts Act. So, my lord was of the view, prima facie that we have something to say in these revisional applications. There are three revisional applications. One is against the order admitting the appeal. One is against the order passing an interim order. And the third one is from refusal to vacate the interim order. So, three divisional applications separate from the same proceeding.
Yes, the interim order is still the disposal of the civil division application.
Yes, yes.
Then why have you mentioned for extension of
No, we did not mention for extension. We mentioned for taking up the matter.
taking up the matter?
But
Yes, and disposing it off, Lord,
I might be
finally.
wrong. But that was our intention. That was our desire, Interim order, we are enjoying.
Contested application, Mr. Banerjee, now it's not possible.
But the difficulty, may I indicate the difficulty?
Uh,
This is a suit for eviction. The land I have
Mr.
purchased.
Banerjee, learned advocate appealing for the petitioner submits that this matter was not mentioned for extension of interim order. In view thereof, let the matter go out of the list for the present.
The difficulty is, RERA is after me. If I don't get the land, the suit is.
After Mr. Banerjee, I have to consider that. Yes, next, call the next matter.
16.
Great.
Is it the same matter, Mr.
60, oh, I'm so sorry, 16, 17, same.
16, 17, same.
Same.
18 also no.
15, 16, 17.
15, 16, 17, same order.
Great.
Yes.
That's right.
What's the document? What's the document?
Item number 18.
Yes, yes.
On 18, we are appearing for the
Extension of interim order.
Yes.
Who is opposing you?
Malad Arjun. Arjun.
Have you stopped?
Malad, yes,
Because
Malad, because his phone number not Malad convenient to me.
That is a copy has been served.
Copy has been served to the client. I have already served. This is
Received.
yes, ma'am.
Mr. Rai, please file ask
Yes,
your
yes.
advocate on record to file
Every five
Evidence.
of
Yeah,
Uh,
in course of this.
on the prayer of the learned advocate on
I'm appearing for the opposite party. I'm appearing for the opposite party. My lord, can you see the last order, my lord?
yes.
My lord, no copy of the application for extension of interim order was served upon me.
Extension of interim order.
Yes, my lord.
My lord, there was no such application.
Why?
My lord, can you
What
see
is the
the?
necessity of application?
No, they have filed the application.
Where? Where do you find the application? After
Kindly see the order, my lord, dated 23rd, my lord, June 2025.
23rd June.
Yes, my lord.
There is no order of 23rd June. So order of 23rd of May.
May.
Yes. Interim order is extended. Where is the
Leave is
application?
granted to the petitioner to file affidavit of service in course of the day.
That was the civil division application.
Yes.
That they are having, my lord.
There is the affidavit of service. You have to be given a copy of the affidavit of service. After hearing the learned advocates for the respect. Yes, who is appearing?
My lord, 20 I appear for the petitioner.
Yes.
The interim order was passed on 24th of April.
Have you
Yes, my lord, the service is being affirmed, my lord. I shall file it in the course of.
Received
Yes, my lord.
on the prayer of the learned advocate for the
Lordship, I beg to appear on the petitioner. The interim order is going to be expired by tomorrow. Lordship, I have served. The only predicament is the advocate on record stuck in Jayan, and the brief is with him.
Have you served?
Lordship, I have served.
Oh, you are appearing, no? Where is the affidavit of service?
Lordship,
Same order. ঠিক আছে আগেরটার মতো yes next
Number 22.
22.
22 yes
This is a affidavit of service, my lord.
what happened
My lord,
everything returned back what is the
return-
endorsement
my lord, 3 times I have
served or not served
my lord, 1 to 8, my lord, first I have served it, it has been returned, that address he has been moved. Again, my lord, I have served, some of them has received. Again, my lord, I have served, one has returned with the postal remark that opposite party number 2 has died.
then
Steps to be taken.
cannot be extended now
No,
the opposite
only
number two.
only one. But
Maybe.
others, my lord,
maybe against the dead person no order can be passed the learned advocate appearing for the
my lord,
petitioner
your lordship kindly
the learned opposite party yes Mr. Chatterjee why are you fighting with your wife
Chatterjee Guru,
Why are you fighting with your wife?
My lord, that much courage I do not have that any person, any husband can fight with their wife. My lord. This is at the just before the argument started, application for maintenance has been filed.
Application
For
for
maintenance.
has to be.
At the argument stage, I am not on that. So the regular maintenance, I am ready to. Area, last 5 years, the suit was continuing. The area has been directed from the date of. One can you consider that?
No, but from the date of filing of the application, it has to be.
Yes, that I could not understand.
But it has been said from the date of filing of the suit.
Yes,
Yes, sir. How can you get that?
it is not my fault.
From the date of filing of the suit,
Mr. Rai, you have to maintain your wife.
April 2025.
If she has no independent income,
Firstly, my lord, the extension for interim order, my lord, this
In 2 months, areas. Areas.
The dealer waiting days, my lord. My lord, thereafter, my lord.
we filed the application.
Key, extension.
Extension to beyond period.
Beyond period.
What is the order which you are challenging? Which order?
Last final order, that is the order dated 17th March 2025, 17th March
From
2025.
the date of filing of the miscellaneous case.
That is on
Miscase.
25, my lord. My lord, may I point certain.
Miscellaneous case, Mr. Rai.
And that,
Not the area of the application under section 120.
yes, but without giving, that is 2 things, my lord. 125 adjustment.
125 adjustment. And so, not from the date of filing of the suit.
No, that.
My lord,
Yes.
submitting the receipt application, my lord.
Yes.
Yeah, it's
Adjustment of the 125 amount. What is the 125 amount?
man can turn to page 5.
Yes. What is the amount of alimony? 25,000.
50,000
And presume not less than 70,000.
and 30,000 litigation cost.
All right. And what is the amount under 125? There is no
4,000.
4,000, my lord. That was
6,000.
That means execution.
And 70,000 presumed to be 70,000. What?
Argument stage. Yes, yes.
That is what, my lord.
He is entitled to adjustment of the amount of
But prior to adjustment, my lord, there has to be certain payments that the husband has to make.
from you have to be directed by when the miscase was filed.
Miscase was filed 2024. Miscase number 603 of 2024.
Yes, what was the date for filing of the miscellaneous case?
It was in the month of December 2024, my lord.
So you are entitled to 1 month in
Subject to
2017 is the suit.
miscellaneous case is 2017.
2024.
This is on 2017 and this application miscase is on 2024, my lord.
Miscase from the miscase 2024 which month?
Matrimonial suit 2017.
Month of December.
December, what is the date?
It's on 20th of December
20th. Mr. R, from January till August,
Yes.
8 months. Even if 4,000 is deducted, 21,000. At the rate of 21,000, bring the amount on Monday.
And this is the amount which I have paid. This is the receipt got by learned friend said. Percentage lordship creation. Rupees 10,000.
My lord's direction, my lord.
All right.
Yes,
20,000
14,000.
of paid.
10,000.
So 10,000 from
So what will be the last amount?
after adjustment, please bring the amount Monday.
My lord, may I point out something, my lord?
Monday they will bring the check, sir.
May I point out one simple thing? What has happened in this case? While Leonard Sinha, while admitting this initial application, had submitted, but if Maran becomes it, the first order, 24th of April 2025.
Yes. 24th of February or 24th of April?
April 2025.
Yes.
My lord, there my learned senior submits that the petition submits that the pursuant to the order passed by
He is paying 4,000. He is not paying.
My lord, we had to file an execution application. My lord, that is still pending.
Mr. Rai, why they have to file the execution application?
Has been showing this order.
Mr. Rai, all right.
My lord, told my execution.
Mr. Rai, without going into that, bring the amount, entire amount due, including that, including 125 on Monday.
Learned friend should take responsibility of his submission.
Mr. Rai,
Case dismissed.
Mr. Rai, that's please take
So I
instruction.
did not.
All right. If there is a, please tell it to him, what is the amount?
So making
Give-
submission is something.
Give the calculations. Mr. Rai, he is also a creature of instruction, something
So
must.
that is why I said that what is the amount I have paid and what is the due.
Give the calculation to him by Sunday and you bring the amount, what according to you is due on Monday. I'm keeping this on Monday.
Application is fixed on 17th of 7/20.
Sir, have you not heard him? He has said your execution case has been, you bring, giving the all right, you giving the calculation, how much is due? Please give him the calculation, he will also take instructions.
Showing the lawful claim of the enforced by
When
MP
can
the
you
contract.
calculation? Sir, when can you give the calculation? Today,
Of the 120 of the
entire,
application.
sir, 25,000 is the entire amount. 4,000 is 125.
125.
According to him, he is paying 4,000.
He is not paying for it.
I started by saying according to him. Sir, you are jumping up. That's the problem. According to you, he has not paid. So you give your calculation, what is the amount due, including 125. So he will also make his calculation, what is due till August. Mr. Rai, please bring the check on Monday. This entry order is till
There is some calculation by
was till July. So nothing will happen. I am keeping it on Wednesday or Thursday.
what is
So you
the
keep the calculation by Monday.
Monday, so I can
Mr.
give it.
Rai, you also give your calculation on Monday.
I'll take it out by Wednesday prevention so we can dispose of the matter.
When this matter is for
the defendant tenant in this matter.
defendant tenant.
24, 20.
These are the opposite party. Yes. Yes.
Interim order is going to expire by this month. Paid for extension. Can one.
The interim order. Now, after hearing the landed 25, who is appearing? Same, 24, 25, same order. Here also application, disposed of application. Yes, next.
Item number 26.
My lord, I want to be the petitioner, my lord.
Yes.
26. My lord, I have served.
You are appealing for the opposite party. After hearing the learned advocates for the respective parties, the interim order is extended till the end of the month of January 2026 or until further orders, whichever. Service taken on record. Yes, call the next matter.
Item number 27.
27, my lord.
Yes,
My lord.
yes. Same order. Yes, next.
Item number 28.
28, Your Lordship, I am appearing on behalf of the petitioner, Your Lordship. Lordship, in this matter, opposite party number 1 has been served. Lordship, there is this is small issue. I am praying, if Lordship, this can be fixed any day, Lordship. Written statement accepted by the learned court beyond 120 days, Your Lordship. That is the small issue that is involved in this matter, Your Lordship.
Appealing for the opposite party. Learned advocate appealing for the opposite, appealing for the petitioner submits that the opposite party has been duly served. To serve in of notice, none appears to oppose the prayer for extension of interim order. The interim order passed on 19th of May 2025 is extended till the end of the month of January 2026 or until further orders, whichever is earlier. Contested application 12 feet, service taken on record. All the next matter.
Lordship, kindly fixes it any day, Lordship's pleasure.
Opposite party, yes. Yes, Mr. Ghosh.
Well, interim order till the end of
August. After hearing the learned advocates for the respective so many applications.
Lord, application, Lord, substitution and section 5. Lord, so many persons, Lord, died long ago. Lord, so, Lord, section, Lord, this is not known to us. Lord, after
Yes,
various,
Mr. Mahato,
Lord,
what do you say to this?
after various, Lord, Lord, they are the plaintiff.
Application for extension of and substitution I have
Substitution, all substitutions allowed. How many substitution applications?
Lord, 5.
Papa.
Lord, five applications in Lord section 5.
Where are those কোথায় সব application গুলো কোথায়?
Lord,
অ্যাপ্লিকেশন গুলো আগে বার করুন তো, সাবস্টিটিউশন অ্যাপ্লিকেশন গুলো কতগুলো আছে?
Lord, 2 to 10.
2 to 10.
Lord,
What is scan 11? What is scan 1?
10, 11, 1 in Lord, I have filed him, Lord, main application, some delay is there. Main
Application delay is there.
some delay is there. Because
Some delay, not much.
Lord, I have Lord, Lord mentioned before Lord earlier.
All right. So
Lord.
can 1 is for condonation of delay. So condonation, Mr. Can 1 you are not opposing? Can 1 টা করে দিন. This is an application for condonation of delay in filing the civil division application. It was taken up, it was admitted.
On 12th of June, my Lord, it was, my Lord.
After hearing the learned advocates for the respective parties, the delay in filing the civil division application stands condoned. Can 1 of 2025 stands allowed. আচ্ছা অন্যগুলো সাবস্টিটিউশন গুলো বার করুন তো, সাবস্টিটিউশন বার করুন।
And 2 to 10, my Lord.
Yes. After setting
Interim order passed, my lord, not, my lord, to stay the execution of the, my lord,
Execution case.
execution case.
Where is the decree? Please show me the decree.
Decree, my lord. The school, my lord, decree is, my lord. My lord, page 33, the decree.
33. Yes.
And 33, 34, my lord, the
33,
hand
34.
10, my lord, 34.
So there is many typographical errors, Mr. Mahato. Do you have a better copy of this? Page 36 is a type copy. There are many typographical errors. Yes, the judgment. Page.
Page 33. That is now 15 of 1993.
Yes, my lord, 34.
Yes, permanently restrained from disturbing the peaceful possession.
Yes.
Yes. Now, what are you? Where is your tabular statement? Now, what are you trying to do? You are trying to take possession, Mr. Mahato.
Yes, my lord. That time, no. No.
All right, Mr. Mahato, I will hear you. I'm extending this because this requires an hearing. Because prima facie permanent injunction, you cannot claim for recovery of possession. There are some. All right, so this is. All right, so this has to be considered. I will consider that. So.
Only point is, my lord, that says in the suit there is no prayer for recovery of possession. Therefore, I cannot.
Sir Mahato, there are two line of decisions. One says permanent injunction, this is to be done.
If it does not appear, when he chooses not to appear, what can be done?
All right, after hearing the learned advocates, the learned advocate. Mr. Mahato, there are many matters fixed, not likely to be taken up on November. That is why the cannulas are disposed of. All can dispose of.
One
Yes,
prayer,
next.
my lord.
On the next matter.
My lord, one prayer, my lord, with regard to item 22, my lord.
Item number
22, my lord.
22. What happened?
My lord, what happened, my lord? I have recorded that all has been served. Actually, 3, 4, 5 has not been served. He recorded that all.
So item number 23 তে ওনার সাবমিশন যেটা বলেছিলাম না সাবমিট sorry 22 it has been submitted by the learned advocate for the petitioner that all the opposite parties excepting opposite party numbers 3, 4 and 5 have been served. All right. Yes, call the next matter.
Now 31.
My lord, 31, I beg to appear on behalf of the petitioner.
Yes.
This is for extension of interim order, my lord. Unfortunately, the affidavit of service is with me. My lord, all have been served. All the opposite parties have been served.
Please keep it with you.
My lord, I will give it to your lordship in the course of the day. I
Sir,
am some
where are
difficult.
you now? Where are you now?
My lord, I am not in court. I will come to court, my lord.
Where are you now?
My lord, I am in some other court, my lord, today. I am sorry.
Senior advocate is saying something else.
My lord, I am sorry. I pray.
Sir, vision, Mr. Munshi.
My lord, my lord, kindly excuses me, my lord. In the course of the day, I'll do that, my lord.
They have been served.
Yes, my lord, they have been served. It has been delivered.
Hearing. So where is the principal opposite party? Where is the principal opposite party?
My lord, they have been served and it has been already been delivered to them.
Mr. Munshi, learned advocate appearing for the petitioner submits that the opposite parties have been duly served. First up, none appears for the opposite parties except the opposite party numbers 3 and 4. 3 and 4. First up, on the prayer of Mr. Munshi, Proforma opposite party code is Proforma opposite party numbers 3 and 4. On the prayer of Mr. Munshi, learned advocate for the petition, leave is granted to the petitioner to file the everyday service in course of this day. The order passed on 13th of June 2025 is extended till the end of the month of January 2026 or until further orders, whichever is earlier. Contested application 12 weeks. Call the next matter.
Grateful, my lord. I'm so grateful.
32 month I'm petitioner.
Yes, petitioner.
Yes, my lord.
Yes, served.
I changed my lord because he can. He is appearing in the
You are for the opposite party.
And for the opposite party, he has requested me to appear. And
He has requested you to appear.
Or he's appearing in lower court, he appeared.
You have got instructions, sir.
I'm in the trial court, I'm taking.
Have you filed Vakalatnama? The learned advocate appearing for the opposite party under
$33. I'm appealing for the petitioner.
yes, served, not served.
No, my lord, this has appeared second time for extension.
Second time, have you intimated them?
Yes, Lord, we have intimated them. Archishman Singh is appearing for the private respondent.
Who is appearing?
Archishman Singh.
Private respondent in a civil division application.
Opposite party. Sorry, my lord. And my lord, Mr. Doctor here and now. Opposite party. And my lord, Mr. Doctor is appearing for the Panihati municipality.
Mr. Rabindranath.
Doctor. My lord, I have orally informed him, but my lord, he has said that his junior, my lord, some HON'BLE, my lord, I do not, he doesn't remember the title. My lord, he has not spoken to him, but he has instructions to appear. But he's unless the
Shall I record in the order, Mr. Chatterjee?
my lord, initially, my lord, his first extension, they both appeared.
No. Mr. Chatterjee, learned
Before I appear for the opposite party, my lord,
34.
yes, in connection with the first order of your lordship, my lord, staying the operation of the order, my lord, I filed a vacating application. My lord, I'm opposing this application for addition of party. My lord,
For addition of party.
sorry, my lord, for extension. My lord, they have suppressed.
When application has been filed also.
So my lord, on the
Who are
very
you?
first,
Who are you?
my lord, we are the parties in the main suit. If your lordship kindly sees, this is a
So this is a demolition order.
yes. Now,
Who are you? That is why I'm asking you. You are the complainant.
yes.
So on the basis of your complaint, an order of demolition of
Yes.
Mr. Basu's premises has been passed.
He's the developer.
That premises.
That premises.
We are the resident of that premises also.
You are the resident of that. You are the
Yes.
flat owners.
Yes.
You have purchased from Mr. Basu or the owner.
Owner.
You have no. Are you the owners or you have the purchasers?
Wants an owner's allocation.
Owner's allocation you have purchased.
Hmm.
Yes. So an demolition order in respect of which portion? Not your portion.
No, total area of more than 2,000 square feet.
Roof.
No, area total.
Yes.
In various parts. Now, the questioning the order of demolition, they have approached the court below. Now, what has happened is, the main primary objection is that the board of councillors were not the appeal before the board of councillors were not placed. Now,
Appeal before the board of councillors.
The appeal under section 218(3)
Yes.
of the Municipal Act was not placed before the board of councillors, and they have not taken the decision. It is the chairman of the municipality who has taken the decision. But the record says
the order has to go.
No. It is their contention. Kindly sees my vacating application once.
According to you, the board of councillors.
Yes, the records also. Kindly take some my vacating application once, your lordship will get the entire picture.
For the municipality, we have not been served with a vacating.
You are appearing for the
Municipality, led by Mr. HON'BLE.
Show me the order of the board of councillors.
Yes. Kindly turns to page 16 once. 16. Page 16 of the vacating. First
page 16 of the vacating.
Yes.
Where is the vacating? Vacating application কোথায় নেই?
Vacating টা জজসাহেব কে দিন। আমাদের নম্বর কত?
Can 2 is vacating.
Can 1 is
1 কোথায়?
আপনার দিন জজসাহেব কে?
Page 3.
Definitive. But kindly see the records. And the next page also.
Perform is getting the records. The civil revision application. Your lordship has
No.
order for calling for the records.
This is the hearing took place before the municipality. The board of councillors have taken the decision.
Why? It is the signature of board of councillors.
Kindly sees the minutes of the meeting.
Yes, yes. Can you see?
The extract of the meeting has been given to us. Everybody was present.
The appeal is pending.
Appeal disposed of, dismissed.
Oh, appeal dismissed.
They have preferred the appeal.
All right, then who is appealing for the municipality? Led by? Where is Mr. Rai?
He is engaged in court number 14.
This interim order is still 31st of. I'm keeping it just after the vacation. Let Mr. Rai come with the municipality has to be heard. There is something more than that. Mr. Bhattacharya, there is something more than that.
Call for the records. May I read this?
Mr. Bhattacharya, learned advocate, appears for the you,
Maybe
so the court has to see what was communicated to you and on the basis of what you have filed.
I'm
right.
grateful.
That is the document.
Mr. Basu, 227 has some wider powers.
My lord,
But
may I-
That's the thing. That's why, my lord, can you call for the records? The court is not season of the matter. It has been disposed of. So it is very easy to call for the records.
Let me see.
I
The municipality is directed to produce the record. I'm
Yes,
not
yes.
saying anything. Let them come. Yes.
The one line, my lord, decision.
What is can 1 and 2?
One filed by me for vacating and two by extension.
extension can dispose of.
Extension to dispose of করে দিন. Can 2 is for extension.
Yes.
Why have you filed an application for any other purpose?
No, purpose is some honorable judges are asking for this. That's the problem.
Within time.
Yes, 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 yes. Yes, even in criminal code also.
Criminal code I don't know. In civil code,
No, we have to file.
Outstation judges sometimes ask.
Not only obsession, my lord, the
Can
honorable
2
judges.
টা disposed of করে দিন. Can 2 টা disposed of 1 টা থাকবে কিন্তু. List
Complete.
can 1 of 2025.
Item number 35.
Yes.
Lordship, item number 35, I am begged to appear on behalf of the petitioner, Lordship.
Yes. Yes.
Lordship, in this matter, Lordship, I am challenging one order passed by the learned trial court, dismissing my application on the under section 11, Lordship. I appeared as a defendant in this matter, Lordship, and on the very initial point, Lordship, I filed one application under section 11 challenging the maintainability of that suit. In respect that, Lordship, the entire issue of this present instance suit has already been decided in an earlier suit. They claim that
The judgment and degree of the earlier suit. Show me the plaint of this suit.
the plaint of the initial suit, Lordship.
Plaint of the present suit, judgment and degree of the earlier suit. Please show me that.
Lordship, am I audible, Lordship?
Yes, yes, sir, you are audible. Please show me, but you are not visible. Please show me the plaint of this suit and the judgment and degree of the earlier suit.
Lordship, then Lordship kindly accommodate me for 1 day, Lordship, as because due to some medical problem, emergency, Lordship, I couldn't address your Lordship physically, Lordship. Kindly accommodate me for 1 day.
So what is the wrong in this order?
Lordship, the entire
Yes, was plot number 1730 of Kadi Mauja the subject matter of the earlier suit?
basic contentions of the entire to take partition of the entire Devatar estate, Lordship. The entire Devatar estate was already been.
Mr. Das, please tell me whether plot number 1730 was the subject matter of the earlier suit, yes or no?
That particular plot number was not mentioned specifically on the earlier judgment, Lordship. That's why,
this application under Article 227 of the Constitution of India is at the instance of the plaintiff. You are the plaintiff.
Lordship, I am the defendant, Lordship.
But you have said plaintiff in the cause title.
Lordship, that may be.
Please ask
Lordship,
who is
Lordship.
in the court.
Lordship, Mohammed Hafiz. I mean,
to correct the cause title on the behalf of the learned advocate for the petition, he is granted to the learned advocate on record of the petition to amend the cause title of the civil division application, comma, here and now, full stop, paragraph. This application under Article 227 of the Constitution of India is at the instance of the defendants and is directed against an order being number 36 dated 3rd of May 2025 passed by the learned civil judge, Senior Division, Kadi District, Murshidabad in partition suit number 163 of 2022. First, by the order impugned the application under section 11 of the Code of Civil Procedure stood rejected. Full stop. The learned advocate appearing for the petitioner submits that the earlier suit for partition between the same parties was dismissed, and the opposite party has subsequently filed the instant suit for partition. He submits that the instant suit is barred by the principles of res judicata. Full stop. On a query of the court, the learned advocate appearing for the petitioner submits the learned advocate for the petitioner, comma, in his usual fairness, comma, submits that suit plot number 1730 of Kandi Mauja was not the subject matter of the earlier suit for partition. First of all, in view thereof, this court is this court is therefore of the considered view that the learned trial judge was right in rejecting the application under section 11 of the Code of Civil Procedure. Full stop. Accordingly, CO number such and such stands dismissed. There shall be however no order as to cast. Call the next matter.
Number 36.
Yes.
For the petitioner.
Yes, yes.
Preempty is the petitioner before your lordship.
Preempty allowed.
It's not that. But my application for marking the purchase receipts, wherein the signature of my vendor is there. The receipts have been marked, but the signature has not been marked. So that application and my application for sending the signature with the admitted signature of my vendor, that is, my lord, appearing in the deed under preemption, should be sent for comparison. Why, my lord, I am coming to this. My lord,
your vendor sold it to you.
Yes. My vendor is not the person who sold.
Yes. So you are claiming to the Borgada under your vendor.
Yes. And there are Bhakchas receipts to that effect. What happened?
And the vendor is denying.
Preemptor is my vendor is brother's son.
Vendor is denying his signature.
He comes up in as witness of for the preemptors because he is the brother's son. Preemptor's brother's son is my vendor. So he comes up and deposes in favor of the preemptor and said, it is not my signature. Similarly, in that conspectus, I applied for both.
Difficult to believe the Bhakchas receipt.
I say,
difficult to believe the
there are other independent witnesses. They have come and deposed in the preemption proceeding that yes, I have shown, I have acquainted with the signature of the vendor, and it is his signature. And in my presence, this has been.
Where is your application?
Yes, my lord. If your lordship takes up, my lord.
Application for appointment of a handwriting expert.
Yes.
Where is that? What is the stage of the suit?
My lord, suit is at the stage of cross-examination going on of my OPW2.
OPW2.
Yes.
You have tendered that receipt.
I tendered at the time when PW2, my vendor, come and wanted to depose in favor of the preemptors. I tendered that
PW2.
Yes, because he is the brother's son. Now, my lord, it's the other way around. It's a real case, but the two documents.
That is why I am telling you. No, it's difficult to believe the.
But it's from Purva Medni. It's from Purva Medni. Yes, my lord, it's there. My lord, everything is very fictional. I also cannot say what is the in reality. But the written objection.
You know the reality, Mr. Mukherjee. You know the reality very well.
But your lordship has a vast experience.
No, I don't.
Your lordship knows credential of these cases. I cannot adjudge from here. But what I find.
Where is the application?
Yes, the application is at page 35. It starts, my lord, or a 26 rule 10 capital A.
And what is the other application?
Yes, my lord, prior to that, my lord, if your lordship takes up page 33, 33 is my application. Exhibit E, it has been marked the Bhakchas receipts, but without the signature. So I say the signature should also be marked as an exhibit. Maybe with objection.
Where is your evidence? Have you annexed?
My lord, I have credit leave because subsequently it has been obtained. No,
But you could draft without that.
no, my lord,
Mr. Mukherjee, you could
I have
draft
a
without that.
handwritten copy, my lord, given by the my lord, advocate. But that's why, my lord, my lord, the kindly takes up, my lord, I have marked in pencil. PW2 cross-examination. I have marked not some portion. My lord, point number 3 kindly takes up. Bhakcha's receipt filed by Firisti on such and such is tendered to the witness. Are these
To PW2.
PW2 my vendor?
Yes.
Are these documents bear your sign? No. Do you have any objection if these signature are compared with your admitted signature? No.
So admitted document is the
the my lord deed, which is under preemption?
Did he deny?
No, deed he has not denied. Kindly takes up thereafter. Yes, point number 7.
Fact that the
6 and 7, yes. And he said, if it is compared, he do not have any objection.
Mr. Mukherjee, this matter has to be heard with the other matter. The other matter which you are arguing, these two are to be heard analogously.
My other side is here, my lord. Kindly do not indicate anything.
No, I'm not indicating anything,
No.
but I'm telling you because some common questions of law and fact are involved. I can get from the evidence. So these two matters are to be heard.
For that matter,
In order
lord,
to
I
avoid
paused some matters to be filed. Even I paused there.
uh, yes,
May I take that minute now for the timing?
yes. Item number 37.
Supplementary.
So that a line according the petitioner is directed to produce the copy of the evidences.
Lord, this revisional application is directed against the order. Lord, getting the petition, Lord, under order 7 rule 11.
Why you have made it so bulky petition? Lord, there are several documents in earlier occasion, they filed a suit that was dismissed. Our next, Lord, they have filed the again suit on the same self cause of action.
You do not have any case for order 7 rule 11. If these documents are to be seen, it definitely has to go to trial. From the documents you have annexed, if it is to be seen in civil division arising out of an order, rejecting an order 7 rule 11.
Cannot suppress anything.
For admission of the civil division application, it's definitely a case that it has to go to evidence.
Lord, I am not on that point, Lord. Lord, here, Lord, I do not want to suppress anything because of that reason, Lord, I am annexing all documents.
That is the plaint.
Lord, the impugned order.
What is the ground under order 7 rule 11?
Two grounds are there. First of all, Lord, cause of action. That in the only original cause
failure to disclose the cause of action.
Failure to disclose the cause of action. And second is it is barred by the laws, particularly section 11 of the Civil Procedure Code.
Section 11 is judicata.
Yes.
It's a mixed question of law and fact. How can it be decided under order 7 rule 11?
Lord, so far that, Lord, that is also a ground. I am telling you, Lord, this is also a ground. Lord, and Lord,
cannot be decided. Evidence had to be brought in. It is to be compared. Cannot be order 7 rule 11.
The cause of action is concerned, Lord, on the self-same cause of action.
Show me on cause of action.
Yes.
Yes, judicata, you do not have any case. Show me cause of action.
Very well.
Where is the plane?
Lord, your Lordship, kindly have a look of the plane that's page 216, second volume.
Page
216, second volume.
Only two documents are necessary. The plaint and the order 7 rule 11. Your plaint starts in the second volume. What is there in the first volume?
Lord, there is the first volume, Lord, the earlier plaint. The earlier plaint and Lord, the others contested. The judgment was passed, judgment decree was passed, that was challenged to this honorable court.
216.
216.
Yes.
Truth formula declaration and permanent injunction. Your Lordship has got it, Lord? The nature of the relief sought for in the plaint. Your Lordship, kindly have a look of that.
Yes, nature is declaration that defendants do not have any right title interest and declaration that the deed of gift. Where is the cause of statements with regard to the deed of gift?
Lord, deed of gift, Lord, they have only pleaded at paragraph 20.
20
at page 223. Print will go again. Print will go. Get print. Get print. Get print. 2020 print. Okay.
Judge on cause of action, show me that.
Lord, your Lordship, kindly have a look of the Lord in impugned order. That is the last page of the third volume. that only the provisions has been quoted. Several judgments have been quoted. So for the internal page 3. Yes. Internal page 3. Non-disclosure cause of action, court should not decide question of law is.
Cause of action has been disclosed in the plain. Look, because cause of action is
Give deed.
not only the give deed.
Yes, only give deed.
No. Give deed that you have do not have any right, and the permanent injunction also.
May I just indicate very short facts, very short facts. It requires It requires here the defendant number 2 to 6 have no right or authority over the property itself.
Defendant numbers
2 to 5, 6.
Who are you?
I am the Matwali of the property, work property.
Which defendant you are?
1. I am the defendant number 1.
And the deed of gift was?
And deed of gift, which was, they have alleged.
Was in favor of?
In favor of
2 to 7.
2 to 7. And particularly that property is not within the scope and ambit of the worker property. There cannot be any cause of action on that. In the earlier occasion, they have also filed on questioning that thing. In that suit, they have not filed the 2 to 7, the defendant there. 2018, they have filed the suit.
By the order impugned, application and order.
The matter, then
Maintainability will also be there. Maintainability will also be there.
Maintainability will also be there. But the question is, since your lordship has been pleased to admit this, all further proceedings still that time. Otherwise, it will.
There shall be an order of stay of all further.
Order
Which matter?
38. জসে উঠে যাবে না এখনই উঠলে আর বসবেন না।
তোর কোনটা আছে?
Today, just now. So that is why, my lord,
Mr. Ryle, honored advocate appealing for
liberty to Forty-eight বলে দিলেন।
48 টা Order number 39.
39, my lord, I am appearing on behalf of the defendant petitioner. My lord, facts of the case is that, my lord, the plaintiff filed a suit for eviction against the defendant, my lord, who is the petitioner before your lordship, in respect of two rooms. In respect of two rooms, my lord, the defendant appeared and filed written statement and also filed an application under section 7(2) of Premises Tenancy Act, my lord, and against the order passed in an application under section 7(2) of the Premises Tenancy Act, my lord, I have come before your lordship. My lord, my humble submission is that, my lord, the petitioner filed this eviction suit in respect of two rooms. My lord, the case of the defendant is that, my lord, the one room was in respect of one room, the father of the petitioner, my lord, was inducted. And after his death, my lord, the defendant inherited the said tenants, my lord, and he paid the rent regularly. My lord, in respect of one room, my lord, the petitioner directly took tenants name. And to that effect, my lord, I have annexed that document. The father of the one suit was filed by the plaintiff, my lord, against the father of the defendant with regard to one room. That suit was dismissed. I have annexed that judgment and degree. Thereafter, my lord, the present petitioner, my lord, filed a suit against the plaintiff for declaration of his tenancy. That was declared. Suit was decreed. My lord, my humble submission is that, my lord, two separate tenancy, my lord, in respect of two separate rooms, the plaintiff evicted, tried to evict the petitioner from the property, my lord. My lord, if your lordship kindly come to the impugned order. My lord, according to the defendant, my lord, he is not a defaulter. He paid rent regularly. But my lord, learned court below, without considering the challenge, my lord, passed the impugned order and came to a conclusion that the amount which has been mentioned in the order is due. And in respect of two separate tenancy, my lord, the plaintiff filed one suit and for eviction in respect of two tenants.
Give me a minute. Where is your application under section 7(2)?
7(2), my lord, page 25, annexure.
Give me a minute.
Annexure C. I have stated everything, my lord. If your lordship kindly see the paragraph number 3.
Yes, the learned trial judge has calculated the rent of two rooms separately.
Yes, my lord.
So what is the difficulty?
Difficulty, my lord, my humble submission is that, my lord, in respect of two separate tenancy, my lord, cannot.
Why? What is the difficulty?
My lord, I have filed every document that the defendant is not a defaulter. My lord, that document has not been considered.
In respect of two rooms, this has been done. In respect of one room, according to you, all the defendants have inherited the tenancy.
Yes.
And in respect of the other room, you are who? What is your name? Only the defendant number one is the tenant.
Yes, my lord. Who is the petitioner before your lordship?
Yes.
But the learned court below, my lord, calculated dues, my lord, in respect of two rooms along.
Where is the difficulty? Where is the difficulty?
My lord, two separate tenancy cannot be. Why?
Why?
My lord,
why?
My lord, he raised the point, section 2G. My lord, the defendant number one is not covered under section 2G, my lord.
No.
Also, raised point section
He has taken
2G.
the point of 2G, but in a suit under section 2G72 is not maintainable. But the learned trial judge has not held that it is not maintainable, has decided the application under section 72. So that is neither here nor there.
Different
But
tenancy, my lord, in respect of two different tenancies.
Please kindly come to order to rule 3.
That has not.
Order to rule 3. Joinder of causes of action. According to you, these are two separate causes of action. Can be joined. Please kindly come to order to rule 3.
CTC, I have not.
Please take it. Order to rule 3. So according to you, these are the separate causes of action.
Yes, my lord.
Can be joined. Order to rule 3. Sir, I took this point. I took this point, I lost. I took this point, I lost.
My lord, the plaintiff, my lord, raised the point section 2G, but I am not within.
The learned trial judge has not accepted 2G, has decided section 72. Now your case is of separate causes of action, separate suits are to be filed in respect of these two tenancies.
Also, I am challenging the quantum of.
I argued this point, I lost. I do not exactly recollect, 10 or 11 suit properties of tenancies were included in one suit. I lost this. And that was, you are a bit early, that was the last day of the vacation. I forgot, might be puja vacation or summer vacation. I exactly recollect that day.
And also,
notice was separate. I'm telling you that. This was separate, suit 1-5. I took this point, which you are taking up
two separate tenancies.
6 or 7 separate tenancies, not to joined in one suit.
My lord, also I have challenged in this revisional application, my lord, quantum of amount, my lord.
That is a different thing altogether. That is a different thing altogether. With regard to joinder of cause of action, no, you do not have any point.
I have filed every challenge, my lord.
That's a different thing altogether. But
that challenge, that documents has not been considered, my lord. According to the defendant, my lord, he is not a defaulter for a single month, my lord.
No, but the learned judge held that no, you are a defaulter.
No, my lord.
Separately, in respect of one tenancy, he has calculated, and in respect of the other room, he has separately calculated.
I have every challenge, my lord.
But what is the finding with regard to those challenge?
My lord, that has not been my lord, in respect of the petitioner's tenancy, my lord.
Tomorrow, after filing the, yes,
My lord, according to the petitioner, my lord, he is
come tomorrow.
my lord, kindly consider Monday is the next date before the trial court, my lord.
What will happen?
My lord,
Nothing will happen.
my lord,
Monday.
my lord, this present
Sir, you have a difficult. Yes.
Mr. YJ Dastur has passed away. I do not know whether Lordship has been informed or not.
Yes.
We have adopted a resolution not to participate from 12.
Not to
Participate from 12 noon.
not to participate.
Most of us would be leaving to pay respect. And we have intimated the Honorable the Chief Justice, and though we should not say, but
Mr. Datta, I do not have any difficulty, but I have to call the list. If any one of you.
that is the reason, my lord, we have requested the Honorable Judges to rise. But though not it's specific in the resolution, we cannot. We have requested. It's a difficult situation.
একদম নামের উপরে দিয়ে দেন তো হাইকোর্টের ক্যালকাটার উপরে দিয়ে দেন।
that date has been fixed before the below.
Nothing will. Yes.
For depositing the rent, my lord, kindly consider, my lord.
Expectedly, it will be reached on the next date.
If not, then I will again come and mention before your lord.
That will happen. Yes, yes. চলো রাখুন। That is at 3 p.m. One larger bench is at 1. So we have to, Mr. Datta, we have to sit, but
one intelligence, my lord, one intelligence before rising, my lord. Well, yesterday, my lord, give leave, my lord.
the assistant secretary is here.
I asked my
The assistant secretary is here. take his permission.
One only extension of time, my lord, yesterday, my lord,
For what?
Not, yesterday failed to file, my lord, without certified copy, one the time.
What extension of time I could not understand.
Yesterday,
He had leave to file without certified
Copy,
copy. He could
yesterday-
not file yesterday. That one
That
day.
was-
leave.
So leave is to be given.
Yesterday granted leave, but my lord, yesterday could not file, my lord, the clerk, my lord, due
So
to.
leave there. You will be filing today?
Yes, my lord.
Leave to file.
That bench, 3 PM bench.
Appear না করলেই হলো, জজ সাহেব বসবেন।
We have to.
জজ সাহেব
We have to.
Come and converge.
I do not know the other side is there, Mr. Bordon, if,
I'll tell Mr. Ghosh. Devnath Ghosh is there. So I'll tell Mr. Ghosh. I'll tell Mr. Dotto. They are by not since
no,
he will be there.
only thing is that not your matter, other matters are also there. So we have to formally sit thereafter.
Judgment, my lord, judgment, my lord.
Judgment is there. If you are present, I can deliver the judgment. Or if
আরে
you
না
want,
থাকলেও তো জাজমেন্ট ডেলিভার হয়ে যেতে পারে। না থাকলেও তো জাজমেন্ট তো ডেলিভার
no,
হতেই
if
পারে।
you want, you can appear for the judgment, you can.
জাজমেন্ট হলে তো আর নাম দিতে হয় না।
If you will appear, then I will come at 2 PM. Please tell me, or
না না দরকার নেই, ছেড়ে দিচ্ছে।
তাহলে ওই Monday রেখে দিন।
Grateful.
Monday তে